Welcome back, guys. Advocates for Justice, Foreclosure Defense Paralegal Service. We are different and we prove it. I'm Coach Neighbors, and today we're going to talk about something very important, jurisdiction. So let me ask you a question. If there was one document you could use to get control of your foreclosure situation, would you use it? What if that one document was affordable? How much would you pay for one document that could help you get control of your foreclosure situation today? Well, I've been working on that one document. I've been working for a while now on coming up with that one document that will stop the foreclosure pretty much in its tracks. And I think this new document that we're going to talk about today will be the one. And there are a few good things about this document. Number one, it's a challenge to jurisdiction with an affidavit. And this is pretty special. By using this jurisdiction challenge with an affidavit, you will be able to file it in their case against you in state court without having to pay filing fees. And you can also use this as your answer, so to speak, as your reply to them coming after you. So a lot of times what I do is I have people use this jurisdiction challenge. If they just served you and you still haven't responded to them, you don't have to respond. You can challenge jurisdiction at any time up to 15 years. And when you challenge court jurisdiction, some judges say, oh, that's improper. Well, I'm not an attorney, so I don't have to worry about what's proper or improper. The law states you can challenge jurisdiction at any time. Well, why not challenge it at the gate? Because if they don't have it, that's the best time to throw it on the table. And we're going to teach you how to do that. In this video, I will show you my new document to challenge the jurisdiction of state court and where you can get the document on sale today. Now, this is one of the most powerful documents that I've structured to date. And I think, as mentioned that in the beginning of the video, this document can be used to attack jurisdiction of any revised statute or code that does not contain the three elements necessary to be considered a valid law. And foreclosure codes or statutes and HOA, they use codes to go after people's property. But in regular foreclosure, I guess most states use the statute. The statute does not have the three elements necessary to be considered a valid law. This jurisdiction challenge can be used for traffic tickets, zoning coding issues, tax collections. Yep, tax collections. All you would need to do is look up the code that they're using to try and steal your money with and do some research on that code or statute to make sure that it's never been enacted into law, which in most cases, I don't think you'd even have to worry, but you have to check that on your own. What I do know is that revised codes and statutes do not have the three elements necessary to be considered a real law, and it's about time we start taking advantage of that. In this video, you'll learn how to properly challenge the court's jurisdiction and force the attorneys to respond on the record. Hey, my name is Guy Neighbors, and I'm a paralegal that don't like what attorneys are doing to people, so I stepped up to do something about it. And that's what this business is all about. So if this is your first time here and you want to learn how to stop your foreclosure dead in its tracks and how to defend yourself and your property against invalid revised codes and statutes, subscribe down below and click the bell so you don't miss anything, because class is in session starting right now. This video will be part of a playlist entitled Tips and Strategies for Court. And we have several other videos in that playlist. I would suggest that if you're in court now, that you go and check out that playlist, because we give you free tips that you're not going to find anyplace else. And if you're the person that can take those tips and put them on paper and use them to block them from going forward, then there you go. There's a tip free for you. Make it happen. If you need help, that's what we're here for. So keep that in mind. Make sure you watch the entire video, because somewhere in the video, I'm going to give you the answer to one of the three missing elements. I'm going to let you know what the main missing element is. Your research and figure out what the other two elements are. And even if you don't know what the other two elements are, knowing what this element that I'm giving you today is the main thing, because that is what you're going to be using to block their attack on you with their revised codes and statutes that do not have all three elements necessary to be a valid law. And when I say necessary to be a valid law, I'm talking about the state constitution. Most state constitutions have it set out where this element is necessary. There are a couple of states that don't have it, but the Supreme Court for, like the state of Georgia, has ruled that this element needs to be in place. So it needs to be there, and it's not. And this is not something that you're going to find out from attorneys, because they don't like talking to them. They're not going to talk about anything that's going to help you. Well, the problem that we've been having is attorneys have been acting as debt collectors, violating the law and rules and procedures, creating defects in the process that rob the court of jurisdiction. You need a document and a game plan that will help you address the defects and challenge the court's lack of jurisdiction. You must hold officers of the court liable for their misconduct, or you will never have a chance to force them to stand down. In this video, I will point out the most common defect rob the court of jurisdiction, and you will see what you need to do about that problem. Now, challenging the court's jurisdiction is the best defense that you can use if someone's attacking you in court. Below is a list of the most common defects. I'll leave a copy of this list in the comment section of the video, so you can copy and paste it. I think the same list was also left in the last video about the HOA jurisdiction challenge, because we basically, it's the same thing pretty much. So you want to make sure that you take a look at those, because if any of those are in your case, then you need to move to have it dismissed, challenge in the jurisdiction, because the court don't have jurisdiction. Proof of jurisdiction must appear on the court record. And once the court has knowledge that subject matter is lacking, the court, meaning the judge, has no discretion but to dismiss the case. And failure to dismiss the action means the court will be proceeding in clear absence of all jurisdiction and subject the judge to sue. Subject matter jurisdiction requires two things. The first one, and this is a very important one, is a competent witness or a notarized affidavit demonstrating an injury. But in trial, that affidavit means nothing if you demand a witness. And in most judicial foreclosures, there's no witness. And the affidavit is actually signed by the attorney, and he's attesting to the fact that he has seen the records. So you've been sued by the records. And that whole thing is wrong. So that's a tip for the day. In a judicial foreclosure, your number one defense is there's no witness. And without a witness, the court don't have jurisdiction, and the attorney can't testify. So keep that in mind. Getting off track here. Okay, so the second element, the statute or common law basis for a remedy of the injury. Now, let's get right to the problem here. The problem is the statute or the code that is used to provide the court with jurisdiction for all foreclosures cases is missing the three elements necessary for the statute to be considered a valid law. There are three elements necessary for something to be considered a valid law as per the Constitution of each state and the federal Constitution. When you figure out what those are, you will be the driver of the bus. That's how I put it. And you will know how to use them to defend you, not only in foreclosure court, but in traffic ticket court. Or the problem is the laws referenced in the complaint have no evidence that they are from any authority to which you're subject or required to obey. And they usually, like in the state of Kansas, they use KSA 60-30 or something, which is a statute. And you go to that statute, and the statute does not contain the necessary elements to be considered a valid law, according to the Constitution. The state constitution requires three elements are necessary for something to be considered a valid law, and you need to do your research to figure out what the three elements are. So once you figure it out, leave a post in the comment section to help the people who haven't figured it out yet. This is a group project. So if you figure out what those three elements are, post them in the comment section down below so other people can see them. So I'm going to open my ShareWin and show you the defects that exist in many cases. Okay. Okay, let's take a look at the subject matter jurisdictional defects that are present in most cases. So I'm wondering how many of those defects are in your foreclosure situation that you're dealing with. Now I'm going to give you the answer to that main missing element. Well, to one of the three missing elements, but it's the main one that I'm going to give you. So without further ado, the missing element is an enacting clause. There you go. And the enacting clause is necessary for something to be considered a real law because it lets you know from what authority the law came from and who's subject to following it. And I think the reason it's missing from the revised codes and statutes is because if it were there, people would understand that those revised codes and statutes are rules from the corporation, and they're not something that you are legally bound to follow without your consent. And if you remove your consent, they have a problem. So that's it, the enacting clause. There are two other elements that are necessary. All three need to be there. If one element is missing, then it's not considered a valid law. And that's it. Could it be that simple? Our jurisdictional challenge with affidavit is a solution to this issue. And you can stick it up in the attorney's face anytime up to 15 years. And jurisdiction can be challenged at any time. So it's not time barred. You can bring it up 15 years later. And they don't like it, but they can lump it because we have Supreme Court case laws to back that fact up. Actually, I have several pages of I'll leave a few of the main ones in the comment section down below too, so you can use them if you need them. The challenge of jurisdiction is never time barred and has no statute of limitations. This document can be filed in their case against you, and you shouldn't have to pay filing fees. And that's the really nice thing about it. It's not the $5.5 million lawsuit package, but this is a nice shot in their gut to get them out of your face. And I'm going to list this at a crazy low sale price of, I don't even want to say it. I feel bad when okay, $200. I'm going to list it for $200 because I want people to be able to use it. I know what's going on right now. I've been talking to people from all over the United States. One lady told me she works in the courthouse and she's about to be struggling with some things, and she's learned that they won't allow people in. They only allow the attorneys in the courthouse, in the title office is what she said, in the title office. So they're getting ready to to start coming after people. So I want to be able to if I can get this one document set up and have it do what it's supposed to be doing and have people be able to stop the foreclosure and for $200, I think that's a great deal. And I think with all the people that need it, I would make well over what I needed to make it worthwhile for the peanut butter jelly sandwich I've been eating while I've been trying to learn how to do this. So now this document addresses the missing part of the alleged contract, showing your version of what you agreed in the original contract. And I know, what am I talking about? Don't worry about trying to back up everything you say, because everything they're saying is all lies anyway. So and when you see what we're talking about here, we're talking about how that process should have taken place in the first place at the signing table, and how that whole thing should have went. It should not have went the way it went, where you owe them like money for the rest of your life and you still never own the property. So when the statute or code that they are using to attack you with is missing the three elements necessary to be considered a valid law, it's not a law that you are required to follow. You need to put yourself in a position to appeal the judge's decision on this issue, not the issue of what they said happened. You want to pick as soon as they stomp on you, that's when you want to step up and address that. If not, then you're never going to have a chance. You have to make the court respect you. Our challenge to court jurisdiction is the best way to answer the foreclosure petition because of the fact jurisdiction can be challenged at any time. And it's the best way to respond to the foreclosure if it's already in progress and you didn't answer, but you're being defaulted, there you go. You can challenge the court jurisdiction. It doesn't matter where you're at. As long as they file the case against you, you can use this challenge jurisdiction. Now, if you're filing a case against them, you can take this challenge jurisdiction affidavit and take the challenge of jurisdiction part out and use the facts in it to support an affidavit of what you're saying actually happened when you sign the original contract. And when you read it, you'll understand what I'm saying. So you can take the information in this and use that information into an affidavit, just stating the facts that we put in there, the facts that are missing from their original contract. That's our claim. And it's going to be up to them to back it up. If they can't back it up, they're going to have to go sit down. Now, this strategy will force attorneys to prove subject matter jurisdiction on the record for the court to proceed. And you're specifically asking the court to force them to prove jurisdiction on the record for him to continue. Now, a lot of times, and I've said it that way because you need to understand, a lot of times when you go into court and you take something they don't want to talk about, which is anything that you get from me, then usually the judge tries to take over and tries to answer on their behalf and tries to throw you out of court for one reason or another. And it usually doesn't work out too well, and especially if you know how to. Most people don't figure out that they can object to the judge's order. You know, the judge issues your order, and a lot of times they don't even give the other party a chance to respond because the judge is trying to help them because they know they're going to look bad. So, yeah, but that's not a problem with us. So we're waiting for them, you know, and people need to understand, especially in my program, man, we're not waiting for the judge to rule on what they said you did or didn't do. Okay, because all of that is fraud. So you can argue it all day. It started out as fraud, and it's in the middle is fraud, and the end is fraud. And if you argue it, you're still going to end up standing in the pile of fraud. So what we do is go in and we attack the issues and things that they did wrong that robbed the court of jurisdiction. And you just saw that whole list of stuff of 15 or 20 things that are common in most cases, but people don't understand that once that starts, the court loses jurisdiction and the program needs to be stopped and the case needs to be dismissed. If the judge fails to do the right thing, you are now in a position to move for reconsideration. And the way we do it is we move for reconsideration, then you will file your notice of recusal and then your notice of claim against the judge. And we do the notice of claim because you don't have to file another lawsuit and do all that stuff. You just stick the notice of claim in there. But the notice of claim is the lawsuit. So all you got to do is change it from notice to claim or whatever, and you're set to go. The idea is to let them see what you're going to be bringing to the table to go after the judge with if they want to keep doing this and give them opportunity to step aside or step out or whatever. But that's what the notice of claim for. So it's actually the claim, but it says notice of claim, so you can actually stick it in their face and give them a chance to decide if they want to go forward or keep doing this or whatever. But in the meantime, you're going to be jamming the judge up anyway. So that's just kind of icing on the cake. And usually what I and it depends on you on this. Usually what I like to do is I usually file all of those except for the notice of appeal. You know, I file the recusal motion and the notice of claim, and then I'll wait a couple of days and then file the notice of appeal before they have a chance to respond. And I like to do that because once you file your notice of appeal, they have no jurisdiction and they can't do anything in the case. So this gives them opportunity this will give you opportunity to get the dirt on the table in the appellate court so people can see what's really going on. And it's just mean to do because it makes them look bad. And that's why we're doing it. So this is one of the document bombs that I put together that you can use to blow up their case if they're using revised codes and statutes against you. You can use this with creativity. You know, if you're facing traffic tickets or zone and coding fines or whatever, you can use this because most of the time, none of those things that they come after you for on the state level have, or very few, I haven't seen any yet, have the three elements necessary for them to be able to use that against you to take your stuff. So this is huge. What you're learning right now is huge. And not everybody knows it. And I don't think you'll find anybody on YouTube that's actually sharing free information with people that can help them out. And providing the documents for the people that need hand so they don't end up on the street. Okay guys, so here you can see on my screen share, this is what the front page of the jurisdictional challenge with the affidavit looks like. And it's a little bit different than what most people generally use, but just follow the program here. You want to replace the red font with your information. When you challenge jurisdiction, you have to make sure that you stay on that. You can't allow them to respond to things and respond to them, because if you start responding back and forth, then you're allowing them to bypass your challenge and continue. So I put together one document because I just wanted to stick it in their face with, needed to have opportunity to make them stand down. So what I did was I put this document together too. And this is your motion to moot all pleadings filed by the attorneys until the attorneys prove subject matter jurisdiction on the court record. So this way you can make moot everything they file, because at the end of the day, the courts can't go anywhere without jurisdiction being on the record, and unless you allow them. So we're not going to allow them to do that. So we're going to ask the court to moot everything that they filed, and now they can stop playing around and either do what they want to do or dismiss the case. It's up to them, because we got all day long. If you were robbed of your house, or if the robbery is currently in progress, this is the best deal ever for you. Now you can get your jurisdictional challenge with the affidavit at my website at winningcourtnow.com, or click on the link below and go straight to the product page and get your challenge to the jurisdiction with the affidavit today and get control of your situation now. Hey, if you guys have any questions about your foreclosure situation or the HOA, or you have an attorney in your face and you need to know how to make them go sit down, leave me a short comment below about what's going on, and I will see if I can give you my opinion on a strategy you need for your situation. And I don't do family court stuff, so sorry about that. If you guys are ready to make this happen, head over to my website, and I will see you in the next video. Well, we're going to talk about our new package that we put together for third-party debt collectors, and we're going to talk a little bit about HIPAA. So I will see you. Don't forget, subscribe down below and click that bell so you don't miss anything when class starts.